That's both a very simple question and it can be quite a deep question. Simplest level, people bring their appeals to the Supreme Court. The Supreme Court agrees to hear the case, which it doesn't have to do. The court has almost complete discretion over what cases it chooses to hear. It sets the case for argument. It takes the votes of 4 justices to hear a case. That's an informal rule. It's not in the law. It's not Congress. The court has decided over a period of years that that's the way they want to work. And 4 is an interesting number because, of course, it's short of a majority. And so if there are 4 justices who feel really strongly about something, we really want to take this case, but we're not sure we can get a 5th vote. They might not take it. They might exercise their kind of judgment that we're going to wait. We're not going to plunge into this. Before the argument, the parties file briefs. The briefs are quite extensive, 50, 60 pages. And friends of the court on one side or the other can also file shorter briefs. And sometimes in a big case, there's more than 100 of those. The court hears oral argument. Used to be for an hour per case. In the era of Zoom and now back to the courtroom, the arguments basically go as long as the justices have questions, can go 2 hours or more. And then a black hole opens up. The justices retreat to their private conference room. There's nobody there except the 9 justices, no law clerks, no secretaries. They discuss the same week as the argument, actually, and they take a straw vote. And whichever side gets a majority, whichever side gets 5 votes, the Chief Justice, if he's in the majority, gets to assign somebody to write the opinion, himself or somebody else in the majority. If the Chief Justice is not in the majority, then the senior Associate Justice, who is in the majority, gets to make the assignment. They retreat to their chambers. They start working. They come up with a draft, circulate the draft. If the draft still holds a majority, that basically becomes the majority opinion. The other side can write a dissent, or if, say, there's only 5 members of the majority and one of the 5 says, I'm with you most of the way, but I sure would be happier if you changed paragraph X to this way. That kind of negotiation is very common. That goes on. But eventually, within the same term that the court has heard the argument, and I stress that because the court stays very current in its work. There are other courts that cases can linger for years and people kind of forget about them, but the Supreme Court is very current in its work. So before the term ends, roughly late June, that decision will issue. So that, in a nutshell, is skimming the surface of complex and intense procedure.